defense that we have for our clients. Anybody can testify and say that the marijuana in that patient's system, the defendant's system, was insufficient to cause impairment. And until Arizona changes the law, there's no scientist in the world that can rebut that. They can't rebut it.
Bravo!
No scientist can say you are impaired by marijuana, and no scientist can say you're not impaired by the marijuana. Yes, ma'am.
Well, because I was going to say, with our zero tolerance and slightest degree, again, saying, you know, that there's no limit, that doesn't make a difference. Because right now, they can still get you for 000, and man, you can get a DUI for that. Again, it's just smelling it in the car, they can just get you again for zero tolerance and slightest degree. And so I warn everybody, like I said, don't use it in your car. Don't tell, if they ask if you smoke, don't, nope, not 24 hours, nope, it's been a week, nope. But they can still, even if it's officer discretion too.
Yes.
If they feel that you have met the slightest degree, you're pretty much done.
Well,
You're pretty much done. So that's why I wonder, you know, how does that, you know, we don't know the limits.
I didn't hear.
We don't know the limits. Again, to us, they use our metabolites against us. Because
well, let me explain. I think you said it's too important.
Well, okay, because I was just saying, I just dealt with that
Yes, ma'am.
myself, personally.
Well, I want to get kind of.
Yeah, so I'm jumping the gun. Oh, because I'm loving what you're saying.
All
I'm
right,
like,
I'm going to
more.
get there. All right, so you're talking about two things. If you look at it from a perspective of alcohol, if you have alcohol in your system, right, you look at blood alcohol content. Blood alcohol content in Arizona and every state in the United States, the amount that you cannot have in your system where you're going to be found to be impaired to the slightest degree is 0.08. So if your VAC is 0.08 or higher, you're deemed to be impaired even if there's no manifestation of impairment. So if I'm driving down the road at 80 miles an hour, I'm not weaving inside my lane, I stop properly at the light, but I get pulled over for speeding, I do a field sobriety test and I pass the field sobriety test. They look at my eyes and determine whether or not I have horizontal gaze and nystagmus, which is basically my eyes generating from left to right when a person tells me to look at a pen. Never do the HGN test, which is horizontal gaze and nystagmus. Never do the field sobriety test because you shouldn't do it because you don't have to do it, all right? Because most people will fail the field sobriety test.
I failed one.
But back to my hypothetical.
No. I won't fail it sober.
If I pass the field sobriety test and I'm speeding, but the officer thinks that I'm impaired by anything, if he smells marijuana on my breath, even though I don't have marijuana in the car, he can ask me for my blood. So, he asks me for my blood. If I say no in Arizona, I'm going to lose my license. Because MPD says if you say no, there's an implied consent. By us signing that little license to get our license, the application to get our license, if we say no to a blood draw, we will lose our license for 1 year. So I'm going to say yes. The problem is, if they draw my blood, if I have 1 nanogram of THC in my system, 1 nanogram for 100 milliliter of blood, that's all they need to say I have marijuana in my system. They cannot say I'm impaired.
Right.
So impaired to the slightest degree normally applies to individuals who have alcohol in their system because they can say if your VAC is between 0.05 and
Blood alcohol
0.08,
level.
you are
Blood
deemed
alcohol
to be
content.
under the influence of alcohol. The issue is if I have 1 nanogram of marijuana, THC in my system, 1 nanogram of hydroxy THC in my system, then I'm presumed to have marijuana in my system. However, they cannot say I'm impaired. They can't say I'm impaired. The only way you can say a person under the influence of marijuana is impaired is based on a test. Now, what they can't do to me is take me to the lab and force me to take some stupid tests to determine if 1 nanogram, 5 nanograms, or 100 nanograms, or 100 milliliters of my blood impairs me. But what they can do is determine how well was I driving. Now, scientists will say a lot of lab reports and articles throughout the nation that most people on marijuana and marijuana alone drive better than a person on alcohol, drinking alcohol. So most people who use marijuana who do not drink alcohol and drive will drive better than a person drinking alcohol. Sometimes drive better than a person that doesn't have anything in his system. So how you win in a case where they're claiming that you were impaired to the slightest degree, most likely they're going to charge you with it. It's called a 138181, impaired to the slightest degree by alcohol or drugs. So if I have marijuana in my system, say at 1 nanogram of THC, and I have like say 0.79 BAC, then I can see a jury finding my client guilty based on the alcohol, but it's almost impossible to find them guilty just based on marijuana alone. And I say impossible because if you have a medical marijuana card, all you have to do is be able to repeat these words. The marijuana in my system was of an insufficient quantity to cause impairment. If everyone who has a medical marijuana card in Arizona can remember those words and can repeat those words on the stand in front of the jury, you should be found not guilty of driving under the influence of marijuana and driving while having marijuana in your system.
Will you repeat those words, sir?
Yes.
Yes.
The marijuana in my system
The marijuana in my system
was insufficient
to
cause impairment.
Got it.
And the way you prove that, the way you laid the foundation for that statement is most people who smoke marijuana have been smoking marijuana for years. Then you get to a state like Arizona, and now you pass this Medical Marijuana Act, and now you can go and get your medical marijuana card. So the way you testify is you tell the jury that, and it's going to be true for most people who smoke marijuana for the past 10, 15, 20 years. And I've been smoking marijuana for 15 years. I know how marijuana affects my body. I will not drive my car or operate heavy machinery if I'm under the influence of marijuana. I just won't do it. I won't work with my kids. I smoke my marijuana outside, not in front of my little babies. Because the jury wants to know that you are a responsible user of medical marijuana. And if you're one-timely using it, smoking it while you're driving, smoking it in front of your children, the jury's not going to like it. But if you're able to tell the jury the truth and say truthfully that I don't do things like that, I don't smoke it before I drive, I medicate at night, I go to sleep, I wake up in the morning, I do not drive my car under the influence of medical marijuana. The problem with that statement is if you smoke enough marijuana, if you are a habitual smoker of marijuana, the marijuana or THC and hydroxy-THC, those metabolites, are going to be in your fat cells. And they're going to leach into your blood throughout the day, throughout the week. There are articles that say that the non-impairing metabolite of carboxy-THC will last up to 2 months, 77 plus days in your system. Normally THC and hydroxy-THC, the metabolites, metabolize out in 6 to 8 hours. But if I'm a chronic smoker or a habitual smoker, it's still going to be in my system. So you got to be able to,